Solicitor of Dentons UK LLP and Solicitors Regulation Authority Limited.
My Lords, I appear with Miss Marianne Butler for the Appellant, Dentons UK and Middle East LLP, an English law firm authorised by the Solicitors Regulation Authority. And as you may have seen from the judgment below, Dentons, or the firm as I will call it, is part of a wider global practice, but only the firm is regulated by the SRA. My learned friend, Mr. Paul Ozum, King's Counsel, appears for the Solicitors Regulation Authority. It discharges the regulatory functions of the Law Society, as you will know, which is the approved regulator under the Legal Services Act. A word on timing, if I may, and subject to the court, I propose to open the appeal until 3:45 p.m. today. My learned friend will then have 30 minutes today, assuming the court is sitting till 4:15, and he will leave me 30 minutes for a reply tomorrow, if that's convenient to the court.
Yes, we always hope that we won't be right up against the buffers of a two-day case. Although this case is very important, it seems to us the central point of principle can be quite briefly expressed,
yes,
and may not need reference to 75 authorities or 1,200 pages of documents, but we'll see.
We'll bear that in mind, my Lord. I should explain, I intend to spend the lion's share of my time on point of law. Grounds 2, 3 and 4, though they're important points, are very simple ones. Turning then, if I may, to the substance, and starting with an overview, the appeal, as you know, arises out of the unchallenged findings of the Solicitors Disciplinary Tribunal following a 6-day hearing in March 2024. The tribunal held that the firm had breached Regulation 14 of the Money Laundering Regulations of 2007 in failing to take adequate measures to establish the source of wealth and funds of Client A. Sources of wealth and funds had to be established because Client A was chairman of a national bank in a foreign state, which meant he was a politically exposed person for the purpose of the regulations. And you will find the relevant terms of the 2007 regulations at paragraph 32 of the judgment below. They've since been replaced by the 2017 regulations, which contain materially the same obligation as regards establishing the source of wealth and funds. The circumstances, as you may have seen, are unusual. The firm had inherited the client relationship from Salins LLP following a merger between the two firms. The firm had wrongly assumed, as the tribunal found, that Salins had already established the client's sources of wealth and funds, and the client relationship commenced some 5 years before the merger. In fact, Mr. Chateau, the Salins partner with responsibility for the client relationship, had not asked the client to confirm the sources of wealth and funds. After the merger, Mr. Chateau became a member of the global combined practice, practicing from New York, and he continued to be the partner with responsibility for the relationship between the global firm and Client A, who was never a member of the firm and therefore never regulated by the SRA, and that's explained at paragraph 5 of the judgment. The tribunal found that the breach of the money laundering regulations was entirely inadvertent, that the firm had relied on Mr. Chateau in good faith, that the breach of the money laundering regulations was not systemic, and indeed that the firm had appropriate policies, systems and controls in place in relation to the money laundering regulations, and that those systems and controls and policies had been applied to the two property transactions which were the subject of the SRA's allegation. Most importantly, for present purposes, it held that the breach of the money laundering regulations was not serious, reprehensible, and culpable, such that it amounted to professional misconduct, with the consequence it held that the firm did not breach Principle 7 of the SRA Principles 2011 or Outcome 7.5, the 2011 Code of Conduct. Principle 7 and Outcome 5, Outcome 7.5 is the focus of the appeal. We'll be looking at it more closely in due course, but you will probably have seen it provides, in essence, that a law firm and a solicitor must comply with its legal and regulatory obligations in relation to their legal practice. As regards Principle 6, they provide, you will have seen, that solicitors and law firms authorised by the SRA must behave in a way that maintains public trust in relation to them and the legal services they provide. Principle 8 provides that law firms and solicitors must run their business and carry on their role in their business effectively in accordance with proper governance and sound financial risk management principles. And on the basis of its assessment that the breach was not serious, the tribunal held that none of the principles engaged by the SRA's case were breached. Importantly, the tribunal also held that the SRA had not followed its own guidance in bringing the prosecution. That guidance was to the effect that only serious breaches of the money laundering regulations would be the subject of disciplinary action. And the relevant references for those important findings are firstly paragraphs 9.378 to 9.383 of the tribunal decision at page 247 of the core bundle, and page 248 of the core bundle, paragraphs 13, Roman 4 and 16.
So what were the last two references? 3?
Paragraph 13, Roman 4 and 16 at page 248, my lord.
Sorry,
No.
and the first two? 9.37.
9.378 to 9.383, page 247 of the core bundle. Now, as I say, the focus of the appeal is Principle 8 and Outcome 7.5, the requirement to comply with legal and regulatory obligations. That's Principle 7 and Outcome 7.5. And in approaching those principles and the Outcome 7.5 in the way it did, the tribunal directed itself in accordance with the law as stated by the three-judge court in Lee Day, and the divisional court comprising Lord Justice Davis, Mr. Justice Foskett, and Mr. Justice Holgate in that case, held at paragraphs 156 to 158 that in order to breach principles, or rather the SRA's core principles of conduct, in order to prove such a breach, it was generally necessary to prove that the conduct relied upon amounted to professional misconduct, and that this required an assessment of whether the conduct would be regarded as serious and reprehensible by competent responsible solicitors, taking account of the degree of responsibility. That's paragraphs 156 to 158 of Lee Day, where we're looking at in due course, but the reference to the authorities bundle is volume 3, tab 32, pages 993 to 994. And the relevant extract from Lee Day was also set out in the judgment of Mrs. Justice Lang at paragraph 52 of her judgment, core bundle, pages 91 to 92. Now, in allowing the SRA's appeal, Mrs. Justice Lang held at paragraph 68 onwards that the requirements of seriousness, culpability, and reprehensibility did not have to be met in order to prove a breach of Principle 7 and Outcome 7.5. All that was necessary, the learned judge held, to prove was a breach of the relevant legal and regulatory obligation. That's page 98 of the core bundle. The learned judge below held that even when considering whether a conduct rule has been breached, questions of seriousness, culpability, and seriousness only arise if they are inherent in the wording or language of the rule in question. That's paragraph 68 to 72 of the judgment. She held that questions of seriousness, culpability, and reprehensibility were not inherent in the language of Principle 7 and Outcome 7.5. That's paragraph 69 to 71 of her judgment. With the consequence, she held that they fell to be considered only at the mitigation or sanction stage, paragraph 79. She also rejected at paragraph 80 the firm's alternative case that the tribunal has a discretion to dismiss allegations founded on breaches of Principle 8 and Outcome 7.5 where the conduct is not serious. And my Lord Justice Bean, when granting permission to appeal, indicated that the proposed appeal raises an important point of principle and that the desirability of having the point decided by this court was a compelling reason why the appeal should be heard. And your Lordship noted that the two cases that have featured in the argument, Lee Day and Beckwith, are decisions of the Divisional Court. Now, the issue of law of general importance in the second appeal may be simply stated. Is the Solicitors Disciplinary Tribunal entitled to dismiss an allegation that a law firm or solicitor has breached Principle 7 and Outcome 7.5 of the conduct rules if the tribunal reasonably considers that the failure to comply with the relevant legal or regulatory obligation, in this case the breach of the Money Laundering Regulations, is not sufficiently serious, reprehensible and culpable to amount to professional misconduct? We've stated a fuller formulation of the same point at paragraph 19 of our skeleton, but that's the essence of the question. And although the appeal is specifically concerned with Principle 7 and Outcome 7.5 of the 2011 Principles and Code, materially the same conduct rules appear in the current code. So the point of principle is not of simply historic interest, and we've given the equivalent, or referenced the equivalent provisions in the current code introduced in 2019 in paragraph 7A of our grounds of appeal, core bundle, page 18. Now, as I shall come on to develop, we submit as ground one of the appeal that properly interpreted, Principle 7 and Outcome 7.5 are only engaged by breaches of legal and regulatory obligations that are sufficiently serious and reprehensible to amount to professional misconduct, and that the degree of culpability will be relevant to that assessment. And our case, as I shall come on to develop, is that this is an implied limitation as a matter of construction on the scope of those professional conduct rules under what we have called in our skeleton argument, Approach 1. And indeed, the judge referred to it as Approach 1 in her judgment. And as I shall come on to submit, three main interpretive factors support this approach to the interpretation of the rules. One, it is inherent in professional conduct rules relating to solicitors that they are concerned with only serious and reprehensible conduct. It has long been the position at common law, which is an important part of the context in which the SRA made the relevant professional conduct rules. And the ratio of the decision of the Divisional Court in Lee Day, which drew on the decision of the Court of Session, Scotland and Sharp, supports this view of the professional conduct rules. The second interpretive factor, which supports this approach to the interpretation of the rules, is that the purpose of the SRA's professional conduct rules is to protect the public and maintain public confidence in the profession. That purpose, we say, is not served by treating every breach of a law or regulation, whether serious or not, as a matter of professional misconduct. And the third interpretive consideration, which supports, we say, our approach to the interpretation of the rules, is that a literal approach to the interpretation of Principle 7 and Outcome 7.5 would give rise to highly unsatisfactory consequences, which as a reasonable regulator, the SRA should not be taken to have intended. It would mean that any breach of a relevant law or regulation, whether or not serious, could be the proper subject of proceedings before the tribunal. That could include minor errors in relation to, for example, employment law, health and safety law, conditional fee agreements and litigation funding, relating to a firm's or a solicitor's practice. So far as the money laundering regulations specifically are concerned, the SRA's own guidance states in terms that only serious breaches of the regulations need to be reported to the SRA. In other words, only serious breaches may be the subject of regulatory action. That's Authorities Bundle, pages 576 to 577. That guidance accords with the guidance of the Financial Action Task Force, which is the international body that coordinates global action against money laundering and whose recommendations were implemented in the money laundering regulations. I'll come on to that guidance in due course. So we say that the tribunal's approach in the present case was in fact no different from the one that the SRA itself takes when deciding whether or not to bring tribunal proceedings. Now, so far I have been summarising the firm's case in relation to approach 1, which is an approach based in interpretation and the principles of interpretation. But we've offered an alternative analysis of the point of law, which gets to the same substantial result, and we've labelled approach 2. And that is that the tribunal has a discretion to dismiss allegations founded on rule breaches that it has determined are not serious and reprehensible, such as to amount to professional misconduct. The finding that a solicitor or firm have breached the rules of professional conduct carries a stigma, and we say that the contention of the SRA that the tribunal must uphold allegations that have been held to be insufficiently serious to warrant disciplinary action is both unattractive and wrong as a matter of the correct interpretation of the statutory scheme.
Again.
We say that the contention of the SRA that the tribunal must uphold allegations, even where it's found that they are not sufficiently serious to warrant disciplinary action, is wrong as a matter of the correct interpretation of the statutory scheme, in particular the relevant provisions of the Administration of Justice Act, which we will come to, and the procedural rules that the tribunal has made pursuant to the enabling statute.
And what has it had the discretion to do what about it?
To dismiss allegations founded on breaches of rules, which it has found to be insufficiently serious to warrant disciplinary action. So under approach 2, the tribunal may find that yes, there has been a breach, but not a serious one, and it has a discretion, we submit, and this is again supported by Lee Day, to dismiss the allegation founded upon a less than serious breach, with the consequence that the solicitor or the law firm does not have the burden of an adverse disciplinary finding.
Does that mean that seriousness is different from seriousness reprehensible?
No, I beg your pardon. No, I'm using seriousness as a shorthand. It's the serious and reprehensible having regard to culpability. Now, the judge rejected that argument at paragraph 80, giving very brief reasons on the grounds the tribunal had no jurisdiction to dismiss allegations on the grounds of insufficient gravity. And as I've indicated, we say the jurisdiction does exist under the Administration of Justice Act of 1985 and the tribunal rules. That's an argument we've developed at paragraphs 29 to 32, and which I will come on to develop in due course. But we do submit that what we have labelled approaches 1 and 2 are different ways of giving effect to the same underlying legal policy, which is that the SRA's conduct rules are concerned with misconduct, and that considerations of seriousness, culpability, and reprehensibility are inherent in professional conduct rules and in disciplinary proceedings to enforce them. We also would point out that the point of law is, as we frame it, reflects the tribunal's understanding of its own disciplinary function. If I could ask the tribunal, please, to, well, I should introduce, we have prepared a supplemental bundle of authorities. I don't know if it's found its way to the court, but we've sent it electronically and hard copies are being made available.
2 hard copies.
What I will do, let me, if I may, just give you the reference, and then we can deal with this afternoon. We do have, thank you. We do have a third copy.
Because unfortunately there's no Wi-Fi here, so I can't access it electronically.
Does your lordship have a?
I don't have the hard copy.
Thank you. This having been handed up, I hope that you will then all have hard copies. This contains just a limited amount of additional material we won't need to go to at all, which we thought we should place before the court. But at tab 7, page 87, you'll find an extract from the tribunal's own website. And it's just the first sentence in the middle. You see the SDT, this is from the tribunal, here's serious cases of professional misconduct. And we say that the way we put the law, whether on approaches 1 or 2, entirely reflects the tribunal's understanding, we say correct understanding, of its function.
What does serious mean?
Well, that is a matter for the assessment of the tribunal, having regard to whether the conduct would be regarded as serious and reprehensible by reputable and responsible members of the profession. I'm going to take you to the Sharp case on which Reday relied to bolster that submission. But it is a matter for the expert tribunal, having regard to the expectations of the conduct to be expected of responsible and reputable solicitors in the context of the particular rule in question that I will develop.
While we're on interpretive factors, can I just ask about the document in the authorities bundle, which I note in fact is not, it didn't come into force until December 2024, which is the SRA Regulatory Disciplinary Procedure Rules.
Yes.
Tab 57.
Yes.
Are those irrelevant to this case because they post-date the events, or are they relevant for any reason?
They are relevant because we can check this, but I believe that materially the same rules were in force in March 2024. But
Well, I mentioned those because those deal with the SRA's own procedures before it gets to a tribunal.
Yes.
And the rule 1.2 appears to define an allegation as, amongst other things, where someone has committed a serious breach of any regulatory obligation. That's rule 1.2b. I wonder what the relevance of that was. Clearly, that appears to be irrelevant given those rules post-date things, but if it was in the same form earlier, I think perhaps we should see that. Yes,
I mean, we will provide those. What I would say in relation to this is that it's in the bundle because it shows the SRA's understanding as regulator that it ought only to be concerned with, firstly, if one looks at A, matters of professional misconduct, and secondly, serious breaches of any regulatory obligation arising under the SRA regulatory arrangements. Now, the regulatory arrangements include conduct rules, but are not limited to them. They include the accounts rules, rules about insurance, and so on. So this is entirely consistent, or indeed the SRA's approach, as evidenced by these rules, is entirely consistent with what we submit is the proper approach to the interpretation and application of all of the conduct rules. But I will come on to develop that.
The reference that you just made before that to the supplementary bundle, the opening sentence appears to suggest an interpretation that there may be cases of professional misconduct which aren't serious.
Well, we submit that professional conduct properly described will by nature be serious. But yes, I take your point about what the tribunal says there, but what I suggest it's seeking to say, well, should be taken as saying that professional conduct, misconduct, is by its nature serious. Well, that's a submission I'll be coming on to
Lord, I
develop.
hesitate to interrupt, but I do
You're
so
going to
because it may
anyway.
assist. I think that document is in the bundle because we referred to it
Which
at our paragraph.
Which document?
The document that the Lord
Okay.
referred to a moment
Yes.
ago, the
Sorry, sir.
2024,
Sorry, sir. Can you move your microphone over to you?
the 2024 version of the what I might describe as the referral test, the screening test. And we referred to it in our paragraph 52.1. That also refers to the equivalent test that was in force at the time, which was the 2011 rules, which is at tab 51 in the bundle. So I hope that is of some assistance to the court and to my learned friend.
Yes, I am. I'm very grateful to Mr. Ozon, and I'm going to come back to the SRA's own rules and guidance. Just on how the issue of law has been framed by the parties, the SRA paragraph 3 of its skeleton argument has sought to frame the issue as being whether solicitors and law firms are required, quote, only to refrain from serious criminality. That's paragraph 3. Now, paragraph 36, it frames the issue as being whether solicitors and law firms are required only to, quote, abstain from serious breaches of the law. That may be a forensically beguiling way of putting the point, but with the great respect, it's not a helpful or fair way of putting the point, because clearly an inquiry into whether a given breach of a legal or regulatory obligation is serious and reprehensible, taking into account culpability, such as to amount to professional misconduct, is a very different and a more exacting question than simply asking whether the solicitor has, quote, refrained from serious criminality or abstained from serious breaches of the law. The SRA's way of framing the issue appears to contemplate solicitors who deliberately or cynically breach the law. Clearly, deliberate breaches of the law are likely to be assessed as serious and reprehensible in the absence of a good excuse or substantial mitigation. But this case is, of course, concerned with an inadvertent breach of the money laundering regulations committed in good faith. Turning briefly to the other grounds of appeal, the judge's conclusion on the point of law led her to quash the decision of the tribunal in its entirety, including all of its findings of fact and conclusions of law, including even that the firm had breached the money laundering regulations, and the learned judge remitted the matter to a differently constituted tribunal for a full hearing. This was despite it being common ground between the parties that any error of law did not affect the tribunal's finding. And of course, the SRA did not appeal any of the findings. And under ground 2, we respectfully say that the error of law as held by the judge did not entitle the court to set aside the tribunal's findings of fact or its assessment that the breach of the regulations was not serious, culpable, reprehensible, such as to amount to professional misconduct, or its finding that the SRA had not followed its own guidance in bringing the proceedings. We submit that the only question that ought to have arisen in light of the judge's decision on the point of law was what, if any, sanction should be imposed for the breach of Principle 7 and Outcome 7.5 on the basis of the tribunal's findings of primary fact and its evaluation of the facts. In relation to ground 3, the judge also remitted or included within the matters remitted to the fresh panel the question whether in breaching the money laundering regulations, the firm also breached Principle 6, which required the firm to uphold public confidence, and Principle 8, which required the firm to carry on its business effectively. And those matters in relation to Principle 6 and 8 were included within the matters remitted, despite the fact that the SRA had not challenged in its grounds of appeal, or indeed at the hearing, the tribunal's conclusions in relation to Principle 6 and 8. So we say under ground 3, respectfully, that the judge was not entitled to remit any question in relation to Principle 6 and 8 to the tribunal. Ground 4, a very short point, or an even shorter point, challenges the judge's decision to set aside the tribunal's order in relation to costs, which was that there be no order to costs, and to order the firm to pay the SRA's costs. Now, before developing the arguments further, I would invite the court to stand back to consider how the case now stands. The matter has been tried over 6 days in the tribunal in March 2024. We have detailed findings of fact and conclusions spanning some 90-odd pages. The error of law we submit does not have any bearing at all on the tribunal's finding that the MLRs were breached, or its assessment that the breach was not serious, culpable, and reprehensible, such as to amount to professional misconduct, or on its finding that the SRA did not follow its own guidance in bringing the proceedings. Whatever the correct position may be on the point of law, it is, we say, clear from the tribunal's unchallenged findings of fact and its evaluation of the facts that it did not consider that the conduct merited any sanction. And it should follow, I will come on to submit further detail, that however this court decides the point of law, if you accept the submission that there are no proper grounds on which an appeal court can interfere with the tribunal's findings of fact and its evaluation of the facts, then there's no need to remit the case to the tribunal for further consideration. All that would be required if you upheld the SRA's position on the point of law would be a declaration, or I should say if you upheld the judge's decision. If you uphold the judge's decision on the point of law, all that would be required from this court, I respectfully submit, would be a declaration that the firm did breach Principle 7 and Outcome 7.5, that otherwise the tribunal's decision should remain undisturbed, and no question of remittal or sanction should arise. Now, that being the case, the court may ask itself, why does it matter whether or not a tribunal upholds an allegation of professional misconduct? It does not impose any sanction.
Is the allegation of professional misconduct?
We submit that any allegation of a breach of a conduct rule is an allegation of professional misconduct and is to be approached on that basis. And we rely on paragraphs 156 to 158 of the lead A, which I'm obviously going to come to support that submission. So, yes, my lord.
Shall we look at those paragraphs in lead A now before we go much further?
Yes, yes. I was going to come on to them, but very happy to go to them now. Your Lordship has them in volume 3 of the authorities, tab 32, 193. And these passages were referred to by the tribunal in its decision. And I want to go through it line by line, if I made, because in the first sentence, the court correctly notes that the function of the tribunal is to decide allegations of professional misconduct. And then at sentences 2 and 3, the initial focus is on Principle 5, which is the duty to provide a proper standard of service. In truth, if such an allegation under Principle 5 is to be pursued before a tribunal, then it ordinarily needs to have some inherent seriousness and culpability. It no doubt can be accepted that negligence may be capable of constituting a failure to provide a proper standard of service to clients. But even so, questions of relative culpability and relative seriousness surely still come into the equation under this principle, that's Principle 5, if the matter is to be the subject of disciplinary proceedings before a tribunal. And then the discussion broadens out, my lords, to the principles generally, at the fourth sentence. We do not, we emphasise, say that there is a set standard of seriousness or culpability for the purposes of assessing breaches of the core principles in tribunal proceedings. It's a question of fact and degree in each case. Pausing there, questions of fact and degree are quintessentially matters for the tribunal, we would suggest. And then it continues, whether the default in question is sufficiently serious and culpable will depend on the particular core principle and issue and on the evaluation of the circumstances of the particular case as applied to that principle. But an evaluation of seriousness remains a concomitant of such allegation. And we submit that that is a general proposition that applies to the SRA rules of conduct generally. And then at 157 over the page, the court begins, if authority is needed for such a proposition, which perhaps suggests that the court considered the point was clear or at least intuitive, and it cites the decision of this court in Wingate and Evans, and also the decision of the Court of Session in Sharp, where it says there, by reference to the applicable Scottish legislation rules, it was amongst other things held that whether a breach of the rules should be treated as professional misconduct depended on whether it would be regarded as serious and reprehensible by competent and responsible solicitors and on the degree of culpability. And my lord, that is the phrase that I had in mind when answering my Lord Justice Bean's question about how one determines whether conduct is serious. And then at 158, the court continues, we consider that though the statutory schemes are by no means the same, the like approach is generally appropriate and required for the English legislative and regulatory scheme in the treatment of alleged breaches of the core principles. We appreciate there may be some breaches of some rules, for instance, accounts rules, see Holden, which can involve strict liability, but that cannot be said generally with regard to all the alleged breaches of the core principles coming before the tribunal, which in our view ordinarily will involve an evaluative judgment and an assessment of seriousness to be made. And then it makes the point that actually the point didn't arise in relation to the specific allegation being looked at there because there was a finding that the solicitor hadn't been negligent. But these passages are nonetheless part of the ratio because when I come back to Lee Day, we will see that the principle here is applied in relation to other allegations and provided the basis on which the divisional court dismissed the SRA's appeal against the tribunal.
Principle 5 in this judgment is failure to provide a proper service to clients.
Yes.
Principle 6 was doing things which don't maintain the
Public trust.
public trust in the profession.
Yes. And the point one gets from this is Principle 5 is an example of a principle where considerations of seriousness and reprehensibility are not, we would suggest, inherent in the wording of the principle. One takes a literal approach to Principle 5. You must provide a proper standard of service. It would, as a matter of language, one would think, capture negligence, for example. But the law is very clear that ordinary negligence, unless it crosses over the line into gross negligence or manifest incompetence. But ordinary negligence is not professional misconduct and would not give rise to a breach of Principle 5. But that's a point I will come back to.
Just looking at paragraph 158, why not? It's acknowledgement that there may be some
Yes.
rules which use the phrase involve strict liability. Those in that example with Holden was the council, so
Yes.
wasn't it?
Yes.
Why would that not apply perhaps to money laundering
Well,
regulations?
the accounts rules are in a class separate category, we say, because they're not conduct rules, they're accounts rules. And it's been established for many decades that they are rules of strict liability. In this case, we are concerned with a conduct rule. The relevant conduct rule is not the money laundering regulations, it's Principle 7 and Outcome 7.5, which is a principle of professional conduct, and therefore we say is covered by the general position as described in paragraphs 156 to 158. But
Do the money laundering regulations create criminal liability?
they can do, but not when prosecuted by the SRA.
Well,
They can be
no.
prosecuted, and there is a specific defence available in criminal proceedings that's not available. A mens rea based defence not available in the tribunal. But yes, they can give rise to criminal liability. Well, I was I'm going to come back to Lido so far as I need to, but that is the key passage. There are other passages we need to see, but we'll see that it's that passage on which the tribunal founded itself when dismissing the allegation. But what I was saying before we went to Lee Day is that the court may ask itself, well, why does it matter whether or not a tribunal upholds an allegation of professional misconduct or a breach of a conduct rule if it doesn't impose a sanction? In other words, if it's found that it's not sufficiently serious, reprehensible, having regard to culpability, to justify a sanction, why does it matter whether or not it upholds the allegation? And the answer is that it matters greatly to the solicitor or law firm in question, because typically a finding of misconduct will do more damage to a reputable solicitor or law firm's reputation and standing than any financial penalty or formal sanction could do. And if I could ask the tribunal please to have a look at volume 5 of the authorities, page 1649, the extract from Gould. Um, 1649 footnote 2. Mr. Gould, in his book on the law and legal...
sorry, Mr. Cullen, I'm behind you. Which volume? And
we're getting volume 5, my lord, tab 66. It's the book by Mr. John Gould, who's the senior partner at Russell Cook, on the law of legal services and practice. And it's just footnote 2 at page 1649, where he says correctly, at footnote 2, that a published adverse finding without a formal sanction may be considered a form of sanction. Now, we say therefore, and that is correct, because of the reputational impact of the finding, and we say therefore in relation to approach 2, that it was entirely appropriate in circumstances where the tribunal had found that the conduct was not serious, culpable and reprehensible, such as to amount to professional misconduct, and where it had found that the SRA had not followed its own guidance because the conduct fell beneath the level of seriousness that would justify disciplinary proceedings, it was entirely right and appropriate that it had the discretion, and it exercised the discretion to dismiss an allegation founded upon a less than serious rule breach. Now, what I'm going to do now, having given that overview, is develop my submissions, if I may, on each of the grounds, focusing on ground 1, which we deal with from page 27 of our skeleton argument, or page 27 of the full bundle, I should say, in our skeleton argument. It's paragraphs 19 onwards. Ground 1 is that the judge was wrong to hold at paragraphs 68 to 80 of her judgment that the unchallenged finding of the tribunal that the appellant's breach of the money laundering regulations was not serious, culpable, reprehensible, such as to amount to professional misconduct, did not justify the tribunal's decision to dismiss the allegation that the firm had breached Principle 7 and Outcome 7.5. And what I'd like to do, if I may, is firstly take you to the decision of the tribunal, and secondly, to make my submissions as to why we say the tribunal was correct to direct itself in accordance with lead A. Starting with the decision of the tribunal, we've summarised the key findings in paragraphs 10 to 15 of our skeleton argument, and they're set out in more detail at paragraphs 3 to 16 of the judgment. In paragraphs 20 to 21 of her judgment, the learned judge cited the key authorities regarding the appellate jurisdiction on appeals from the tribunal. That's page 83 of the bundle. And if we could just look briefly at the citation from the decision of Mr. Justice Morris in the case of SRA and Ali, which you've got at the top of page 84. You see that it stated that the decisions of specialist tribunals, this is the top of 84, are not expected to be the product of elaborate legal drafting. Judgment should be read as a whole, and in assessing the reasons given, unless there's compelling reason to the contrary, it's appropriate to take it. The tribunal has fully taken into account all the evidence and submissions. That's the top of page 84.
This doesn't really help us on the point of principle, does it?
Well, what I'd like to do is, I'm going to, it's subject to, what I would like to do is take you to the judgment just to see how the tribunal approached the point of principle and why it reached the decision it took. But I'll do it very, very briefly. If we can take up core bundle 9, please. And we can pick up the judgment at page 202. It's the decision of the tribunal, page 202, which sets out, in this part of the decision, the SRA's case, which was set out over some 40 pages, and that paragraph 9.76, the SRA's counsel, Mr. Ramsden, then summarised how the SRA put its case in terms of breaches of the principle. And you can see at 9.176, it was argued in the first sentence that a breach of the money laundering regulations automatically gave rise to a breach of Principle 7 and Outcome 7.5, regardless of seriousness. And then in the second sentence, it was acknowledged that Principles 6 and 8 were only engaged by serious breaches of the money laundering regulations. And then at 9.177, the next paragraph, the SRA set out its case as to why the breach of the regulations was sufficiently serious to put the firm in breach of Principle 6. And particular reliance was placed on what was called a KCS report, which had advised caution in any dealings with client A, extreme caution. and reference was made to misgivings about retaining him as a client. But as we'll see when we come on to the tribunal's reasons, the tribunal found that the firm had considered the report with care and came to a reasonable conclusion that it could continue to act. The KCS report did not support the SRA's case on breaches of the MLRs. That's paragraph 9.370 when we come to it. And then at 9.178, it set out the SRA's case as to why the breach of the money laundering regulations was sufficiently serious to put the firm in breach of Principle 8. And again, particular reliance was placed on the KCS report. The firm's case is then set out at paragraph 9.179. And again, the points I'm making here will also be relevant to the question of grounds 2, 3, and 4 and remittal. Your Lordship see that at 9.180, various mitigating factors were drawn to the tribunal's attention. May I just draw your attention to 3, which are the first 2 bullet points. There was no allegation against any individual at the firm. The second one was no issue arose in relation to the firm's systems and controls. And the third point, the 4th bullet point, there was no allegation that the firm had grounds to suspect that client A was involved in money laundering during the period in question. And then at, you go forward please to page 238. Page 238, you'll see paragraph 9.330, the submission to the tribunal that even if the firm did breach the MLRs, any such breach was not sufficiently serious, reprehensible, or culpable to warrant a finding of a breach of the principles or the code to warrant disciplinary action. And the argument was developed over the next paragraphs through to 9.35 by reference to Lead A and Sharp. Your Lordship see the citation of the passage from Lead A that we looked at, both paragraphs 156 and 158, and also citation to Sharp over the page. And at 9.337, submissions were made as to the consequences if the SRA's position was upheld. In particular, that it would mean that any breach of any rule or any law or regulatory obligation could be the proper subject of tribunal proceedings. And at 938, the firm drew attention to the fact that the SRA's position was not consistent with its own regulatory guidance, which required only serious breaches of the money laundering regulations to be reported. 9.338, my lord, at the bottom of 239. It was submitted that the SRA's position was contrary to its own guidance in the money laundering regulations, which required only serious breaches of the regulations to be reported. And the submission was made at 9.340 and 9.341 that this particular case was beneath the threshold for reporting and therefore beneath the threshold for regulatory action. And then what follows are essentially submissions on the law. We can go now, please, to the tribunal's findings, which start at 9.359. At the bottom of page 243. And we can pick them up, please, at page 245, 9.370. This concerned the KCS report on which the SRA's allegation was heavily based. And you can see that at 9.370, the tribunal found that the claim that the firm had considered the report with care and came to the reasonable conclusion that it could continue to act, and that the report did not support the SRA's case on breach of the MLRs. And then over the page, please, 9.372. In the last sentence, the tribunal rejected the SRA's case that the firm was required to obtain documentary evidence of the source of wealth and funds. But then in the following paragraphs, we have the findings in relation to breach, which was to the effect that the guidance had made clear that the relevant person should ask questions to the client regarding sources of wealth and funds in order to satisfy the obligation of regulation under Regulation 14. Paragraph 9.374, the firm had relied on Mr. Shutter in good faith, but he'd never asked the question. And that leads to the finding at 9.376 to 9.377 that the firm breached the money laundering regulations. And then over the page, please, we have the tribunal's findings in relation to misconduct from the top of page 247. And I would ask the tribunal, please, to, if you haven't had the chance to do so already, to cast your eye over the half page under the heading of misconduct, where you see that the approach the tribunal took. In particular, you see the test that was applied at 9.380 was whether the breach of the MLRs, the money laundering regulations, was serious, reprehensible and culpable such that it amounted to professional misconduct. And you have the ultimate finding at 9.382 that it wasn't. And we submit that that approach was unimpeachable in law. It reflects what we have termed approach 1, which is that the principles of conduct and the code of conduct require an assessment of whether the conduct is serious, reprehensible and culpable such as to amount to professional misconduct. That's approach 1. But if necessary, it can also be justified on the basis of what I have termed approach 2. That is, that the tribunal has a discretion to dismiss allegations based on breach of the principles and code if it determines they are not sufficiently serious and reprehensible to warrant a finding of professional misconduct. And then the section on costs is important for present purposes because the SRA sought an order for costs, and in opposing the application, the firm, and this is over the page at page 248, paragraph 13, made various submissions, including Roman 4, that the SRA did not follow its own guidance in bringing the prosecution. And that is a reference back to the guidance we saw at paragraphs 9.338 to 9.339 of the decision, to the effect that the SRA only requires serious breaches of the MLRs to be reported, it being implicit that only serious breaches warrant disciplinary action. So that was the submission at 13 Roman 4, and you see at paragraph 16 that the tribunal accepted the submission. That, and the SRA doesn't dispute this, 13 Roman 4 and 16 read with the guidance which had previously been set out in the submission section at 9.338 is a finding that the matter fell beneath the level of seriousness for disciplinary action in the SRA's own guidance. And it was on the basis of that evaluation of the facts that at paragraph 17 you see the tribunal dismissed the allegation.
So the guidance was all about reporting.
Reporting, yes.
You imply from that
Yes.
it follows on that relates to then taking action as well.
Well, I do, because if if the breach is not serious, it doesn't need to be reported. As a matter of common sense, the reason it doesn't need to be reported is that it's not something the SRA is interested in, and that can only be because it's not potentially the subject of disciplinary or other regulatory action. So we make 2 points at this stage in relation to the decision of the tribunal. One is it did correctly direct itself in accordance with Lead A. The second is that we submit that it's clear from the tribunal's findings that regardless of whether or not it directed itself correctly in law by reference to Lead A, it clearly considered that the conduct was not serious and reprehensible enough to warrant any disciplinary sanction. And that was entirely in accordance with the tribunal's own guidance in relation to sanctions, which recognises that the tribunal may make no order in relation to findings that are not sufficiently serious. And the references in the tribunal's guidance to that effect, if I can give it to the tribunal, to the court, please. It's we don't need to go to it, but it's Authorities Bundle Volume 5, tab 64, at page 1613. It's actually the current guidance, but it was in materially the same terms in March 2024. Perhaps we will take it up, please. Tab 64. It begins at page 1613, and if we go forward, please, to page 1615, you see under the introduction that the guidance consists of a distillation of current tribunal sanctioning principles brought together in one document. Then at the first hole punch, it's explained that the function of the tribunal is to protect the public from harm and to maintain public confidence in the reputation of the legal profession and those that provide legal services for honest, probity, trustworthiness, independence and integrity. The public must be able to protect a high standard of service from a competent and capable solicitor. And then the next paragraph, second line, the tribunal adopts broad guidance. Its focus is to establish the seriousness of the misconduct and from that to determine a fair and appropriate sanction. And then over the page at 1616, we see under principles of procedure, one of the orders the tribunal may make is no order. That's the second hole punch. And then at page 1618, under purposes of sanction, there is the well-known citation to the judgment of Lord Bingham as the Master of the Rolls and Bolton and the Law Society as regards the purpose for which the tribunal imposes sanctions. The last one being the fundamental one at all, the last one, the quote, the most fundamental of all is to maintain the reputation of the solicitor's profession as one in which every member of whatever standing may be trusted to the ends of the earth. And then under the head, and Bolton is in the bundle for your note. I don't think we need to go to it. You'll be familiar with it, but it's volume 1 of the authorities, tab 6, and this extract appears at pages 117 to 118 of the authority bundle pagination. And then in the middle of the page, under the tribunal's approach to sanction, there's citation to the Fuglers case, the decision of Mr. Justice Popplewell, who explained the basic approach to sanction as involving 3 stages. The first stage is to assess the seriousness of the misconduct. And then at 1622, a few pages on, please, there is guidance in relation to determining sanction and how to assess seriousness. We don't need to go through the detail of that. The last point we get from the guidance, if we can go forward, please, to page 1626, there is guidance in relation to particular sanctions. and you see that the first sanction is no order. The tribunal may conclude that having regard to all the circumstances and where the tribunal has concluded the level of seriousness of the misconduct or culpability of the respondent is low, that it would be unfair or disproportionate to impose a sanction. And we respectfully submit that whatever view one may take on the point of law, it is absolutely clear, reading the tribunal's findings of fact fairly, and its assessment of the seriousness or degree of seriousness of the conduct, that it did not consider that this was an appropriate case for a disciplinary response. That's inherent in its finding that the conduct was not serious, reprehensible and culpable, such as to amount to professional misconduct. If it had thought that the conduct required sanctioning, it would not have reached or made the assessment we say that it did, reading the decision fairly. That is why we submit, in relation to the other grounds, that whatever view one may take on the point of law, even if your lordships were to uphold the decision of Mrs. Justice Lang on the point of law, the appropriate response would simply be to declare that there had been a breach of Principle 7 and Outcome 7.5, but not to remit the case for further consideration. Now, I would like next, if I may, to go to the relevant conduct rules, because we say that the conduct rules, properly understood, support the view that as a matter of interpretation, the conduct rules are only engaged by conduct that is serious and reprehensible, take into account culpability and any other relevant factors, such as to amount to professional misconduct. We are, of course, concerned with the 2011 rules. They've since been replaced by new rules in 2019, but the point that I'm addressing is really one of general application, although, of course, our focus is particularly on Principle 7 and Outcome 7.5. The SRA's conduct rules were made under a statutory power to make rules for the conduct of solicitors and recognised bodies through which they practice. We've given you the references in paragraph 22A of our skeleton. There are a number of enabling powers. They include the power to make accounts rules, to make rules in relation to insurance, and indeed other matters relating to practice. But the relevant enabling power was the one to make rules for the conduct of solicitors and the law firms through which they practice. It is an important point that we are concerned with conduct rules, not rules relating to accounts or insurance or any other matter. And as I say, we've given you the statutory references in paragraph 22A. If we could look, please, firstly at the 2011 principles, which you've got in volume 4 of the authorities bundle. Beginning at tab 49. These were the principles.
Sorry, I do apologise. What tab you want?
Yes, my lord, it's tab 49, page 1344. These principles applied both to individual solicitors and the firms through which they practice. And at page 1344, one can see that they are made pursuant to the power to make rules in relation to conduct. And over the page at 1345, the bottom of the page, we have some notes. Note 2.1. The point is made that the principles embody the key ethical requirements. And the principles are set out at the beginning of the page. Principle 1, And of course, they need to be considered and construed as a whole in their relevant statutory and other contexts. Principle 1, you must uphold the rule of law and the proper administration of justice. 2, you must act with integrity. 3, you must not allow your independence to be compromised. 4, you must act in the best interest of each client. 5, you must provide a proper standard of service to your clients. That's just what we were looking at when we looked at Lee Day a moment ago. 6, you must behave in a way that maintains the trust the public places in you and the provision of legal services. 7, you must comply with your legal and regulatory obligations and deal with your regulators and ombudsmen in an open, timely and cooperative manner. And 8, you must run your business and carry out your role in the business effectively and in accordance with proper governance and sound financial and risk management principles. 9, you must run your business or carry out your role in the business in a way that encourages equality of opportunity and respect for diversity. And 10, you must protect client money and assets. Your Lordships also see at the bottom of the page under the notes that there's provision as to what to do when 2 or more principles come into conflict. The principle which takes precedence, turning over the page, is the one which best serves the public interest in particular circumstances, in particular the public interest in the proper administration of justice. Now, there are 4 points I would invite the court to note in relation to the principles at this stage. 1, they have not come from nowhere. They are the expression of the core professional duties of solicitors developed by the common law regarding matters such as the solicitor's duty to the court, see for example principle 1, fiduciary, contractual and common law duties that the solicitor owes the client, for example principles 3 and 4 and 5, and the solicitor's duty to uphold public confidence and to serve the wider public interest. That's the first point. Underpinning these principles is a common law which has been developed over many years. The second point, and related one, is that they are framed as broad ethical requirements. And we submit that it's implicit.
Are they all ethical? I mean, some of these seem to be more a question of efficiency rather than ethics.
Well, they're described as ethical requirements, and they are in the sense that, for example, the ones relating to efficiency, if not discharged, may impact or prejudice the client. So in that sense, they are intended as ethical obligations to protect the client, the public, and the wider public interest. So, my Lord, I submit, yes, they are ethical requirements, and that's how they should be seen. That's how they are correctly described in paragraph 2.1. And we submit that as ethical requirements, they are intended to be interpreted in the context of the general law regarding solicitors' professional conduct, including, as I'll come on to argue, that solicitors should be disciplined only for conduct or misconduct that is serious and reprehensible, taking account of culpability and any other relevant considerations. So we say, thirdly, having regard to their ethical nature, or their nature as ethical requirements, each of these professional principles of professional conduct have 2 essential elements to any assessment of whether they have been breached. And principle 7 is no exception. The first element is an evaluation of whether the solicitor or firm has committed conduct described in the principle. The second element is an evaluation of whether that conduct would be regarded by competent and responsible solicitors as serious and reprehensible, taking into account culpability, so as to amount to professional misconduct. And that is the point in the Scottish case of Sharp and in Lee Day at paragraphs 156 to 158, which we've looked at, which drew on Sharp.
Should we look at Sharp? Or is it simply all
I'm going to take your
lordship
lordships to Sharp. You can look at it now, or I can take it to you in due course. But can I suggest I take it to you once we've looked at Lee Day, because you've seen a description of Sharp already in paragraphs 157, I think it is, of Lee Day.
Yeah.
So we submit, and this is the core error in the judge's analysis, this is the fourth point. The judge's view that questions of seriousness, culpability and reprehensibility only arise when they are inherent in the language or wording of a particular principle is not correct. That's see paragraph 68 to 72 of the judgment. And this can be illustrated by reference to the principles, because the only principles where considerations of seriousness, culpability and reprehensibility are inherent in the actual language or wording, I would suggest, a principle 2, integrity. Difficult to imagine a case involving lack of integrity which is not serious. And principle 6, public confidence. But what I'd like to do is give you some examples by reference to the other principles to illustrate the problems in the judge's approach, that questions of seriousness, culpability and reprehensibility only arise when they're inherent in the language or wording of the rule. Starting with principle 1, you must uphold the rule of law and the proper administration of justice. A solicitor or law firm that has failed to identify and disclose a relevant document, in one sense, in a literal sense, may be said not to have upheld the rule of law or the proper administration of justice. Considerations of seriousness, culpability, and reprehensible are not inherent in the actual language of the principle, but it would be obvious to any reader reading this in context, who understands the duty to the court and who understands that this is a rule of professional conduct, that this principle will not be breached by conduct that is not culpable at all. On the other hand, if the consequences of the failure in relation to disclosure have been serious and there has been some culpability, then an assessment clearly would have to be made as to whether the conduct was sufficiently serious and reprehensible to amount to professional misconduct, such as to engage the principle. And in practice, the tribunal would likely draw a distinction between ordinary negligence on the one hand and gross negligence or manifest incompetence on the other. And of course, deliberate or reckless failure to make disclosure would clearly engage principle 1. And when we come back to Lee Day, we'll see that one of the allegations did indeed concern a failure to disclose a particular document, and the divisional court agreed with the tribunal's assessment that it wasn't sufficiently serious to engage the rules of conduct. Another example may be given by reference to principle 5, you must provide a proper standard of service. We say, applying the judge's approach, that it's difficult to see that considerations of seriousness, culpability and reprehensibility are inherent in the actual language of the rule. But a solicitor or law firm who provided a negligent service would come within the language of the rule. They wouldn't, in one sense, be providing a proper service, but it is well established that ordinary negligence is not the proper subject of disciplinary proceedings. They would not, therefore, engage principle 5.
You say it's well established. Would you like to give us a sacred text
I've
which
given you
establishes it?
Can I give you a reference? It's not a sacred text because it's merely our skeleton argument. But at paragraph 20 today, we've given you the references to the decision of Lord Denning and Rees Solicitor, and more recently to the decision of Wingate and Evans, the Court of Appeal, although that particular case related to Principle 6. But it is well understood that ordinary negligence is not the proper subject of disciplinary proceedings.
Well, I think, unless you're going to come to it very soon anyway, we probably ought to look at the sources you rely on for that proposition.
I will come. Another example may be given for Principle 8, which is that you run your business or carry out your role in the business effectively and in accordance with proper governance and sound financial risk management principles. Again, we say the judge's approach can't work in relation to Principle 8 because there's nothing inherent in the language of Principle 8 that requires an assessment of seriousness, culpability and reprehensibility. If one were to interpret Principle 8 in isolation from the professional conduct context, then it could engage any failure whatsoever to act in accordance with proper governance and risk management principles. And yet the judge acknowledged at paragraph 72, correctly we say, that considerations of seriousness are relevant to Principle 8, and the SRA accepts that as well. But we respectfully submit that it's not clear why on the judge's approach, which simply asks whether seriousness is inherent in the wording of the rule, it's not clear why Principle 8 would require any consideration of seriousness, culpability and reprehensibility. Whilst the judge is undoubtedly correct, we respectfully say, in her view, that Principle 8 is only engaged by serious and reprehensible conduct. It does, we submit respectfully, that it demonstrates a criterion based on the wording of the rule does not serve to distinguish between those rules where considerations of seriousness and reprehensibility do arise and those where they do not. And Principle 9 further illustrates this. The requirement to run your business or carry on your role in the business in a way that encourages equal opportunity and respect for diversity. There's nothing in the wording of Rule 9 or Principle 9 that requires an assessment of seriousness and so on. And if this were to be read in isolation from the professional conduct context, it would, on its face, cover even a well-intentioned failure by a law firm or solicitor to run their business or carry out their role in a way that encouraged equality of opportunity, even if there was no question at all of unlawful discrimination. And Principle 10 again illustrates, we respectfully say, the difficulty in the judge's approach. You protect client money and assets. There's nothing inherent in the wording of Principle 10 that requires an assessment of seriousness, culpability and reprehensibility. And if this is read in isolation from the professional conduct context, it would cover any failure to protect client money, including if the firm was an innocent victim of fraud or cyber hacking in relation to its client account, and without any negligence on its part whatsoever. And we respectfully say that the same problems do arise in relation to Principle 7, with which we are directly concerned, that you comply with your legal and regulatory obligations and deal with your regulators and ombudsmen in an open, timely and cooperative manner. This is not, of course, a new professional obligation. Of course, as a general proposition, a law firm or solicitor should comply with the law and their regulatory obligations, particularly as it relates to their practice. And indeed, the previous code from 2007 contained some detailed provisions in this regard. We've included some examples in the supplemental bundle, but we don't need to go to it. They're at tab 5. I simply make the point that it's always been the case, for obvious reasons, that a solicitor should comply with the law. But we do say that Principle 7 does require the same evaluative exercise to consider whether the conduct would be regarded as serious and reprehensible.
You agree with the first article that the judge found that the language doesn't necessarily evoke an evaluative exercise.
No, well, that's what
language itself.
The language doesn't. But we as I,
you agree with that?
Yes, I agree with that. But I say that's true with the other principles that we've been going through. So I absolutely agree. If the judge's approach is correct in principle, then yes.
But failed to take into account that these were, you say, ethical principles.
Indeed, and we do say, therefore, it does require the same evaluative exercise, and it's covered by the Divisional Court's reasoning in Lee Day, paragraphs 156 to 158, that the core principles of conduct generally require an evaluation of the seriousness and culpability or reprehensibility of the conduct, taking into account culpability, in order to determine if they've been breached. and we do submit that it's inherent in Principle 7, that it's only concerned with breaches of the law that are serious, culpable and reprehensible, such as to amount to professional misconduct. The context is, of course, that legal and regulatory obligations are complex. No doubt some breaches will, by their nature, always be serious and reprehensible, such as unlawful discrimination on the grounds of a protected characteristic. But it's not hard to think of breaches of legal and regulatory obligations that may not be serious. And we do submit that the SRA cannot reasonably be taken to have intended objectively that all breaches of the law, all breaches of regulatory obligations would be covered by the principle without regard to their seriousness and reprehensibility. And as we've already seen, the policy of the SRA is that some breaches of the MLRs are not serious. And the same point arises in relation to the second limb of Principle 7, which further, I respectfully say demonstrates the problem in the learned judge's approach, because the second limb is that you deal with your regulators and ombudsmen in an open, timely and cooperative manner. Now, on a literal approach to that limb, if a solicitor or law firm is late with a response to a regulator or ombudsman, they haven't dealt with the regulator or ombudsman in a timely manner, they would put themselves in breach on a literal approach. But here again, we say it demonstrates the fundamental point that all of these rules require an assessment of seriousness and reprehensibility. So those are the principles. If I can turn next, please, to the Code of Conduct, which you've got in the next tab. And you see at page 1356, there is an overview which explains that outcomes-focused regulation concentrates on providing positive outcomes which, when achieved, will benefit and protect the clients and the public. The SRA Code of Conduct sets out how outcomes-focused conduct requirements that you can consider how best to achieve the right outcomes for your client, take into account the way your firm works and the client base. And then over the page, 1357, there is reference to the principles, which are said to define fundamental ethical and professional standards. And then at 1358, the structure of the code is explained. In the middle of the page, each section is divided into chapters dealing with particular regulatory issues, for example, client care, conflicts of interest and publicity. And then this is important. These chapters show how the principles apply in certain contexts through mandatory and non-mandatory provisions. And then it's explained that the mandatory provisions are the outcomes, of which outcome 7.5 is an example. And it's explained at the bottom of page 1358 that the outcomes describe what firms and individuals are expected to achieve in order to comply with the relevant principles in the context of the relevant chapter. So there you see the clear link between the outcomes and the principles. And then over the page at 1359, it's explained that there are also what are called non-mandatory provisions. And these are indicative behaviours and notes. And it's explained that the outcomes are supplemented by indicative behaviours. The indicative behaviours specify but do not constitute an exhaustive list of the kind of behaviour which may establish compliance with the contravention of the principles. They're not mandatory, but they may help us to decide whether the outcome has been achieved in compliance with the principles. Now, the SRA, in paragraph 37 of their skeleton argument, page 61 of the core bundle, say that the 2011 handbook, quote, was intended as a radical departure from the regulatory regime to which solicitors had previously been subject. And the suggestion made by the SRA in paragraph 37 is that the 2011 code and principles represent a break with common law misconduct, essentially. And to support the proposition at paragraph 37 of the skeleton,
No,
it's page 61, my lord, of the SRA's, of the core bundle. It's you pick up the middle of paragraph 37, where it's dealing with what is said to be two main criticisms that the firm makes in relation to the judge's judgment. And then about 5 lines down, the first is that she focused too narrowly upon the grammatical meaning of the words of Principle 7, Outcome 7.5, without considering the wider limitations inherent in the professional conduct rules arising from the general law. However, the SRA handbook was intended as a radical departure from the regulatory regime to which solicitors had previously been subject, and the citation is made to Cordery and other sources. And the suggestion, as we read it, appears to be that the 2011 handbook was intended as a break from the common law, or at least that one could not derive much assistance from common law misconduct. And one of the sources you see cited is Cordery on legal services, the reference for which is volume 5 of the authorities, tab 67, 1657. I don't propose to turn it up, and I'll see how my learned friend develops this point, but what Cordery says in terms of the radical departure related to the use of outcomes and indicative behaviours to express professional obligations, which was seen then as a new or novel drafting technique. But none of the commentary cited by the SRA suggests that the 2011 code was a radical departure so far as the nature of professional misconduct was concerned. And then if we can return, please, to the Code of Conduct, back to page 1360. You see a list of contexts divided into chapters. The relevant chapter is chapter 7, management of your business. And go forward, please, to page 1362. We have chapter 7, management of your business. Top of the page, this chapter is about the management and supervision of your firm's or in-house practice. And at the second hole punch, it says that the outcomes in this chapter show how the principles apply in the context of the management of your business. So again, we have the relationship between the principles and the outcomes, and a relevant outcome you've got at page 1363. You comply with legislation applicable to your business, including anti-money laundering and data protection legislation. Now, here again, as with the principles, we respectfully submit that outcome 7.5 is clearly a rule of professional conduct. That's not in dispute. It is made pursuant to the enabling power in relation to conduct rules. And we say that as a matter of construction, it covers only breaches of legislation applicable to the business that would be regarded as serious and reprehensible by competent and responsible solicitors, taking into account, of course, culpability or indeed any other relevant factors, such as to warrant the conduct being characterised as professional misconduct. Those are the rules of conduct. If we can go back to Lee Day, because as no doubt your lordships have already sensed, or certainly it's my submission, that the answer to this appeal on the point of law really does lie in Lee Day. The SRA, on the other hand, says at paragraph 47 that reliance on lead day is a somewhat arid argument, quote unquote, before this court, as it's a decision at first instance. It doesn't, of course, bind this court. It does not negate the need to interpret Principle 7 and Outcome 7.5 in accordance with the principles of interpretation, paragraph 47 of their skeleton. But we respectfully suggest that this court will derive considerable assistance from the decision of the divisional court, although, of course, Principle 7 and Outcome 7.5 were not an issue in Lead A. The case does lay down the broad principle of general application in paragraphs 156 to 158. The case, or the point, was strongly argued on both sides, both in the tribunal and in the divisional court. And the decision also shows how the tribunal itself, in practice, deals with allegations of rule breaches that it considers are not serious enough to warrant findings of professional misconduct. And we have addressed Lead A in paragraphs 21 to 23 of our skeleton argument, and I would, beginning at page 29, I would ask the tribunal please to look in particular at 22A, starting at 22A, where we set out the propositions for which we say Lead A is authority. And I would like to offer, if I may, that's a slightly more succinct and workable statement of what we say the ratio of Lead A is. I'm not seeking to depart substantially from what we say in 22A, but simply to put it in a more succinct and workable form. We submit that the ratio of Lead A is that in order to prove allegations founded on breaches of the SRA's rules of professional conduct.
Just a minute, if you're
yes, I appreciate the importance.
you want us to write it down,
Yeah.
we'll write it down.
We
In
say
order to prove.
Yeah, in order to prove allegations founded on breaches of the SRA's rules of professional conduct, it is generally necessary to prove that the conduct relied on amounted to professional misconduct, and this involves an assessment of whether, in the context of the particular rule of professional conduct, the conduct would be regarded as serious and reprehensible, by competent and responsible solicitors, taking account of the degree of culpability, now, the reasoning of the divisional court supports both what we have termed approach 1 and approach 2. As regards approach 1, which approaches the problem as a matter of construction, we rely in particular on paragraphs 156 to 158, but also paragraphs 102, 153, and those paragraphs were also quoted in the judgment below, paragraphs 51 to 52. And we say that the divisional court supports approach 1 because it said in the paragraphs I've given you that the SRA's professional conduct rules generally require an assessment of whether the conduct that is said to give rise to the breach is sufficiently serious, culpable, and reprehensible to warrant a finding of professional misconduct. So that's approach one.
Can I just ask, when you use the word generally, are you meaning generally but there are exceptions, or generally across all of them?
The divisional court acknowledged the possibility in the passage we saw that there might be exceptions, and it gave the word, the example of the accounts rules. And that's why, being faithful to the decision, not seeking to take it further than what was actually said, I say generally. My submission is that the approach in 156 to 158 lead A, in fact, applies to all of the SRA conduct rules, but at least certainly so far as this appeal is concerned, Principle 7 and 7.5. The only exception identified is the accounts rules. That is not a conduct rule, not made pursuant to the accounts, to the conduct enabling power.
Why does that matter?
Well, the nature of I only point, my lord, to the enabling power because it underpins or supports the correct characterisation of the rules. They are rules of professional conduct. It matters to my argument because I submit that as a rules of professional conduct, they ought to be approached as such, consistently with, among other considerations, the approach taken at common law.
You presumably have got Holden in our authorities.
We have, and I'm going to come to the accounts rules exception. But just on the reasoning of the divisional court, I said it supports approach one, but it's important to note that it also upheld the decision of the tribunal to dismiss certain allegations founded on rule breaches that were not sufficiently serious to amount to professional misconduct. And that provides some support for approach two. And the relevant paragraphs in the divisional court's decision, 216 to 220, 225, 228, 236, and 237. But whether one prefers approach one or two.
Well, there's listed in your skeleton.
They are, my lord, at paragraphs 20, I think it's 22.
Oh, yes.
22A.
Right, yes.
But either approach, one or two, reflects, we submit, the underlying legal policy that conduct that is not serious should not attract the finding of professional conduct. Now, the facts, of course, in Lead A were complicated, but they can be summarised shortly. The SRA prosecuted wide-ranging allegations against Lead A, its senior partner, Mr. Day, and two other solicitors in relation to misconduct allegedly committed in the course of acting for claimants and civil claims arising from allegations of unlawful killing and torture by British soldiers in Iraq in 2004. The allegations made against the British Army prompted the Al-Swedi public inquiry, and the inquiry found that the complainants had fabricated the allegations, and this led to the SRA scrutinising the conduct of some of the lawyers involved, including Lee Day. Now, the tribunal dismissed all of the allegations against Lee Day and its solicitors. Some of them were dismissed on the basis that any breach of the rules was not sufficiently serious and culpable to amount to professional misconduct. And the SRA's position before the tribunal in that case, and on appeal to the divisional court, was that the seriousness and culpability of the misconduct was relevant only to sanction and not to whether the allegations of rule breaches should be upheld. In other words, the SRA argued for the same approach that advances on this appeal, and indeed which succeeded before Mrs. Justice Lang. And the tribunal and the divisional court both rejected the SRA's approach to the interpretation and application of the conduct rules for the reasons we have already summarised. See paragraph 22 of our skeleton. Now, to understand the reasoning in Lee Day, it's helpful just to have in mind the relevant rules that were considered in that case, and the judge has helpfully set them out in paragraph 50 of her judgment. If your lordships could please go to page 90, which contains a convenient reference of the rules that were in play today. This is under the 2007 code. The first three were what might be called high-level obligations in relation to the rule of law, independence, and public trust. Then there were also some detailed and quite technical rules under Rule 8 and 9 relating to fee sharing and arrangements with introducers. And then at Roman 5 and 6, you see Principle 5, you must provide a proper standard of service to the clients, and Principle 6, you must uphold public trust. Principle 5 and Principle 6 were from the 2011 principles that we've looked at, whereas the rules at Roman 1 to 4 in this paragraph are all from the 2007 code. Now, I would like, if I may, to start with the tribunal decision, because it informs an understanding of the approach in the divisional court, and also we submit provides a helpful understanding of how a tribunal, the Solicitors Tribunal, understands its function when considering breaches of rules which it does not consider sufficiently serious to warrant findings of professional misconduct. And we have the decision at volume 3. Tab 27. And you see from page 645 that the case was strongly argued on both sides.
6-week hearing.
Page 645, appearances. You see the case was...
Yes, well, 24th of April to 9th of June.
Yes, it was
quite a hearing.
That's the longest. And this point that we are concerned was considered, as we see from the judgment, exhaustively by the tribunal, with very senior representation on both sides of the argument. And then, if your lordships can go forward, please, to page 671. The first allegation related to a press conference given by the lawyers, which was alleged to be in breach of the high-level principles concerned with integrity, independence, and public trust. And if we could, the allegation set out at 671, we don't need to concern ourselves with the details at this stage, but could I ask the tribunal simply to note at page 695 the approach of the tribunal, which then drew criticism in the divisional court from the SRA. You see at paragraph 141.81, just around the second hole punch, the way the tribunal framed the question in relation to the press conference allegation. The question was whether the content of the press conference, taken as a whole, was reasonable in attempting to achieve an investigation on behalf of his clients. Or more precisely, and this was the key sentence, the subject of criticism by the SRA, more precisely, had the applicant shown beyond reasonable doubt that it was so unreasonable for the first respondent and PS to have said what was said at the press conference that it constituted professional misconduct. And then the tribunal proceeded to hold that it wasn't so unreasonable.
But sorry, what is the principle which the press conference was said to breach? Or 3 rules?
Yes, they
compromising your independence.
Yeah, acting with integrity
Acting
and
with integrity.
diminishing public trust. And then the next group of allegations begin at page 700. Allegations 1.2 to 1.4. And these concerned a failure to ensure that a relevant document, or a document that was said to be relevant, was disclosed to the Al-Swedi inquiry and also to related judicial review proceedings. Now, that document was said to evidence that the claimants and witnesses who were making allegations of torture and unlawful killings might have actually been engaged in the battle as part of militias, not innocently working in the fields as they had claimed. And the tribunal dismissed that allegation, but we'll see that it features in the discussion the point of principle when we get to the divisional court. And then at page 762, we've got the point of, we get to the allegation where the point of principle is discussed. This is allegation 1.8. And it concerned an allegation that a junior solicitor had destroyed an original translation of what was said to be the key document, or a key document, known as the OMS detainees list. She'd done it actually after typing up the translation and without appreciating that it might be significant. And she was actually acquitted on the facts of any negligence. The relevant principles that were said to have been breached were Principle 5, provide a proper standard of service, and 6, uphold public trust. And it was this allegation that gave rise to the discussion of principle in paragraphs 156 to 158 in the decision of the divisional court that you've seen. The submissions of the SRA begin at 162, but the key passage starts at page 764, paragraph 145.12, first bullet point, and this is recording the submissions of the SRA, where it was submitted that Principles 5 and 6 were conceptually distinct and were neither intended to nor in fact impose the same threshold for breach. Principle 5, which required a proper standard of service, would by definition be breached where a solicitor had not provided a proper standard of service without more. Principle 6, by contrast, required a solicitor's incompetence to reach such a level that public trust in the profession was at risk. As had been illustrated by recent authorities on the issue, mere incompetence on particular facts, as distinct from manifest or serious incompetence, might not be sufficient to constitute a breach of Principle 6. The important distinction between these two principles was that under Principle 5, the tribunal was not required to assess the seriousness or degree of incompetence in order to find breach. The only question was whether there had been a failure to provide a proper standard of work. By contrast, Principle 6 required the tribunal to consider the seriousness of any error or incompetence in determining whether public trust was damaged. And then that's all the SRA's submission. The law firm's response, the response to solicitors to that argument, is at page 767. And you see it, paragraph 145.19, it was submitted that to prove allegation 1.8, the applicant was required to show beyond reasonable doubt that the third respondent's submitted mistake was 1, in breach of the rules, and 2, sufficiently serious such as to amount to misconduct. And that argument is developed in the next two paragraphs, 145.20 to 145.21. And the tribunal unanimously upheld that argument of principle at page 769, a few pages on, at paragraph 145.32 to 145.33. I'd ask the court please to note what is said in those paragraphs. I won't read them all. I won't read them out in full, but you see at 145.33 that the court gave particular weight to Sharp and the Law Society, and also Holden and the SRA. Those cases lent specific support to the conclusion that there is a difference between being in breach of a rule and having committed professional misconduct. It seemed to the tribunal to be self-evident that the solicitor should provide a proper standard of service to his or her clients. That's always been the case, and Principle 5 was an articulation of that fact. And over the page, however, it did not follow that failing to provide a proper standard of service, in other words, negligence, constituted professional misconduct, and certainly not professional misconduct that should come before the tribunal. The tribunal rejected the applicant's assertion in relation to Principle 5 and determined that negligence would need to be serious before constituting professional misconduct. Lord, your Lordship asked about authorities earlier, which I mentioned the decision of Rear Solicitor Lord Denning going back to 1972. But what we get from this passage is undoubtedly, I respectfully submit, the understanding of tribunals, or at least this tribunal, the Solicitors Disciplinary Tribunal that ordinary negligence ought not to be the subject matter of disciplinary proceedings. And then, so that approach really reflected what we had termed approach 2. In other words, there may be a breach of the rule, but it wasn't sufficiently serious to justify a finding. And then the next allegation on this point.
Sorry, Mr. Cullen. but let me catch up. Yes.
And then we see a similar approach, but a slightly fuller and still, I suggest, more helpful discussion, beginning at page 805, allegation 1.5, or at least in relation to allegation 1.5, which concerned a referral fee paid to a non-lawyer, MY, which was said to be prohibited and improper, essentially because the necessary information about the fee and the fee sharing arrangement had not been given to the client. And also it was said to be an unlawful contingency fee because it related to a claim arising out of death or personal injury. And you see from the allegation that it included breaches of Rule 8 and 9 of the 2007 Code, which, as I've indicated, detailed and in some respects quite technical provisions relating to the information to be provided to the client about the fee sharing arrangement and the relationship with the introducer. And then if we can pick up the discussion, please, at page 811. Uh, 1432, so 148.32, last sentence, you see that the tribunal did hold that the payment was made in breach of Rule 9 and 8. The question then was, with what consequence in terms of the tribunal's ultimate finding? And at paragraph 148.3, it cited to the decision of Sharp, which you've already had a glimpse of, I think, from the tribunal's decision in our case, which quoted Sharp in the passages I took you to. But the key passage is that there are standards of conduct to be expected of competent reputable solicitors. A departure from these standards, which would be regarded by competent reputable solicitors as serious and reprehensible, may properly be regarded as professional conduct. And then over the page, the court or the tribunal cited Holden. And then at 148.35, it concludes, first sentence, the tribunal was satisfied that as a matter of law, there was a difference between an act that was a breach of the relevant rules and an act being professional misconduct. And then at the bottom of the page, last sentence, in the tribunal's view, this could not be said to be sufficiently serious to attract the opprobrium of a finding of professional misconduct, and accordingly the tribunal dismissed allegation 1.5. Both the tribunal and the divisional court recognise correctly, we say, that a finding of a breach of a conduct rule is a finding of professional misconduct that attracts opprobrium and should only be made where the conduct is sufficiently serious and reprehensible to justify such a finding and such professional opprobrium. And we submit respectfully that both the tribunal and the divisional court in Lee were right to view it in that way. And the tribunal took a similar approach to other allegations. I'll give you the references, but probably don't need to go to them, but the references are paragraphs 14.62, page 788. Sorry, it's 14. No, I've sorry. The other paragraphs are 146.62, page 788. 146.65, page 789. And 147.46, page 803. And finally, if we could just look at the tribunal's order in Lee Day at page 856. You can see that the allegations were all dismissed, notwithstanding the finding that some of the rules had actually been breached, but in a way that was less than serious and reprehensible to justify the opprobrium of a finding of professional misconduct. And if we go next, please, to the Divisional Court in Lee Day, tab 32. Again, strongly argued on both sides. One sees from the representation. And if we could start with paragraph 1 at 964, please, where it's recorded that the tribunal dismissed all allegations of breach of professional conduct rules. It's perhaps an obvious point, but the Divisional Court correctly saw that these were all rules of professional conduct. And I've already taken you to the key passage in relation to 156 to 158, which concerned the structure of the translation of the OMS detainee list. And if we could go back, please, to so 156 to 158, please, at 984. We say that the core passage at 156 to 158 does support approach 1.
Sorry, which page are you on?
This is 993 to 994. And can I just draw your attention to an important point when we come to consider Beckwith at 156, and it's the last two sentences. It's the penultimate sentence in particular, at the bottom of 993. It's whether the default in question is sufficiently serious and culpable, thus will depend on the particular core principle in issue and on the evaluation of the circumstances of the particular case as applied to that principle. Here we get the distinction with Beckwith, because in Beckwith, as we'll come on to see, the court held that you don't ask whether the conduct amounts to professional misconduct as a freestanding question, divorced from the rules. Here we see from paragraph 156 to 158 that it is not a freestanding question. Whether the default in question is sufficient or serious and culpable thus will depend on the particular core principle the court says an issue, and on the evaluation of the circumstances of the particular case as applied to that principle. So the question of seriousness and reprehensibility is considered in the context of the particular rule of conduct in issue. That's what Lead A, I respectfully submit, correctly says at 156 to 158. And the passage at 156 to 158 supports what we have called approach 1. That is that the SRA's conduct rules generally require an evaluation of whether the conduct would be regarded as serious and reprehensible by competent and responsible solicitors, such as to amount to professional misconduct, taking account of the degree of culpability. And that approach is one based in the proper interpretation of the rules. And we respectfully submit, going back to the judge's core reasoning at paragraph 68 to 72 of her judgment, that the approach of asking whether the requirements of seriousness and reprehensibility could be inferred simply from the language of Principle 7 and Outcome 7.5 does not reflect the statement of principle in Lead A, and indeed was wrong in principle. May I also address a point made in paragraph 48?
You say that in every allegation of breach of conduct rules, as opposed to the account rules, must be dismissed unless the behaviour concerned would be regarded as serious and reprehensible by competent and responsible solicitors.
Yes.
And until Lead A, this point had never surfaced, had it?
Well, it does reflect the common law, which I'll come on to. That is the approach taken, certainly in relation to lawyers, solicitors, and the barristers under the common law. The point had not surfaced in the sense that before Lead A, no, there hadn't been a decision of the High Court certainly which had taken this approach, but it does reflect, as we say in our skeleton argument, the approach in practice of the tribunal, and it also reflects, we say, the approach the SRA itself takes to the rules. But I'm conscious, my lord, and the challenge has been made by the SRA. One's got to address the point also as a matter of principle, and I'm going to come on and say why we say Lead A is correct as a matter of first principle, having regard to the appropriate principles or the relevant principles of interpretation. But can I just address a point made by my learned friend in paragraph 48.2 of his skeleton, which you've got at page 64 of the bundle. Where Lead A is sought to be explained, this is towards the end of 48.2, on the basis that at paragraph 156 to 158, the language of professional misconduct was simply being used as a proxy language, it's put, for breaches of the alleged standard. We say that it's perfectly clear from 156 to 158 and the reliance drawn from Sharp that the concept of professional misconduct was fundamental in the divisional court's view to the proper interpretation and application of the SRA's professional conduct rules. So it's not simply being used as a proxy for something else. They also say, this is the SRA paragraph 52.1 of their skeleton argument, that the SRA scheme does not define prescribed standards by reference to any defined notion of professional misconduct. I think in response to my Lord Justice Zacaroli's observation earlier, we saw in fact that the SRA's rules do refer to allegations based on professional misconduct. We don't need to turn it up again, but the reference is Authority Bundle Volume 5, tab 57, pages 149 to pages 1449 to 1450. And then the Divisional Court applied the same principle to other allegations. If we go, please, to page 981 of the bundle. This concerned the allegation about the press conference, and you'll recall I took you to the passage in the tribunal decision where it framed the question in terms of professional misconduct. And at 102, the Divisional Court answered the criticism made by the SRA, including by asking rhetorically at the end of 102, but what we asked was this allegation doing before the tribunal if it was not an issue of misconduct. And those observations were made specifically in relation to the rules in play in that allegation, which concerned independence and public trust.
That's the press conference.
That's the press conference.
Yes.
But we suggest the same question arises or would arise in relation to any breach of the conduct rules, including Principle 7 and Outcome 7.5. And then the next allegation concerned the alleged failure of disclosure in relation to the OMS detainees list. And it's important to note that some criticism was made of Lee Day in relation to its failure to identify the relevance of this document and disclose it sooner. But the point of principle was applied at paragraph 143 of the judgment. If you could go, please, to page 991. Paragraph 143, the appeal with regard to these two allegations must be dismissed. In so deciding, we do not say that the respondents individually and collectively do not merit any criticism for these oversights. They do. And in fairness to them, they have strongly criticised themselves. But that is not to say that such lack of competence and such oversight as were involved necessarily were of a degree such as to constitute misconduct coming within the ambit of Rule 101 and 106. They related to upholding the rule of law, the proper administration of justice, and public trust. So again, we say that approach supports approach 1, which is that considerations of seriousness and reprehensibility are inherent in the rules. The court then addressed the more technical allegations under Rule 8 and 9 about fee sharing and arrangements with introducers. And when we submit that these this part of the Lee Day judgment is illuminating because unlike the previous allegations, these allegations did not concern high-level rules of conduct, but the specific prohibitions and requirements of Rule 8 and 9. They were certainly not rules where the requirements of seriousness and reprehensibility could be said to be inherent in the language of the rule, and to that extent, they were materially similar to Principle 7 and Outcome 7.5. And if we can, the allegation which you've already seen is set out at page 1005. It's allegation 1.5. We don't need to go back to that. We can pick up the judgment, please, at 1007. At paragraph 216, you've got a summary of the decision of the majority of the tribunal, including at Roman 3 that the breach was not so serious as to justify a finding of professional misconduct, and so the allegation was dismissed. And then that approach is upheld by the divisional court at paragraph 220. It rejects the criticism of the SRA. This part of the judgment is suggestive of approach 2. In other words, you've got a breach, but it's not sufficiently serious to amount to professional misconduct. And then at paragraphs 221, the divisional court turns to the other aspect of the alleged breach, which was the said to be impermissible contingency payment, or the payment of a prohibited referral fee. And you see from 221 in the first line that the tribunal did find that there had been a breach. I think you've already seen that, but we've got the court's conclusion at 228, where the court held that there was no basis to justify this court treating the majority decision on either the application of the rule or its assessment as of seriousness as wrong. And then at 229, the divisional court then turned to the prohibition against the payment of contingency fees in relation to claims arising out of death or personal injury. And we see the conclusion in relation to that at 236, which again is in terms that the tribunal was entitled to find that although there'd been a breach of the rule, it wasn't sufficiently serious to justify a finding of professional misconduct. So we respectfully submit that in this court, Lee Day is persuasive authority for the proposition that to prove allegations founded on breaches of the SRA's professional conduct rules, it is generally necessary to prove that the conduct relied on amounts to professional misconduct. And this requires an assessment, which I'm repeating what I've already given you as the ratio. This requires an assessment of whether in the context of the particular rule, the conduct would be regarded as serious and reprehensible by competent and responsible solicitors. And we submit that the central insight in paragraphs 156 to 158 of Lee Day in particular is that the nature of professional conduct rules necessarily requires an evaluation of seriousness and reprehensibility. And we say that that insight applies with the same force to Principle 7 and Outcome 7.5 as it applies to any other rule of professional conduct made by the SRA. Public protection and maintaining confidence in the provision does not require any departure from the general position stated in Lee Day. And as we've seen, the SRA's own enforcement and reporting policy in relation to the MLRs supports this. Now, my Lord will have just been asked about Sharp, which you see the Divisional Court drew on at paragraph 157 to 158. We've got it in volume 1 of the authorities, tab 4, page 25. Decision of the Scottish Court of Session. Very simply, partners of a firm of solicitors Scotland have been found guilty by the Scottish Disciplinary Tribunal, Solicitors Tribunal, of misconduct by contravening the accounts rules. And the relevant rule is set out at the bottom of page 96, but it essentially required that every solicitor in the firm had to ensure at all times that the sum at credit in the client account should be no less than the amount of money held for clients. And one sees in the last paragraph of page 96 that under section 23 of the relevant Act, if any solicitor failed to comply with the accounts rules, that failure may, emphasise may, be treated as professional misconduct in proceedings before the disciplinary tribunal. And in this case, the firm had operated over several branches, and the partner in charge of one of the branches had made improper transfers out of client account that had resulted in a shortfall. The other partners, innocent.
Improper in the sense of wicked or
Well, in breach of the accounts
Contrary
rules,
to
I think there
rules.
may have been an element of wickedness, reading the tribunal fairly, but anyway, in breach of the accounts rules. But the key point for these purposes is that the other partners were not aware of the transfers. But they admitted breach of the accounts rules because they had an absolute obligation to ensure they were complied with, but they denied professional misconduct. The discipline tribunal found that they were guilty of professional misconduct on the basis that the partners had not taken reasonable steps to prevent the breaches. And the Court of Session on Appeal held that the tribunal had not properly considered the question of professional misconduct. And we can pick up the judgment, please, of Lord Elmsley at the bottom of page 100, who said that the second misdirection may be seen in the following passage of the note. Quote, Mr. McEwen invited us to apply ourselves to the question whether the respondent's conduct was disgraceful or dishonourable, but in our opinion, those questions should be confined to common law charges of professional misconduct, and that following the division contained inquiry on solicitors, a charge founded on a breach of the accounts rules or other practice rules might be regarded as statutory grounds for misconduct, and that in such circumstances, somewhat different considerations apply. So that's what the discipline tribunal had said. And then Lord Elmsley continues, what these, quotes, somewhat different considerations, close quotes, are, the tribunal does not say. And there is no support whatever to be found in Cordery on solicitors for the view that professional misconduct resting upon a breach of a rule is different from professional misconduct resting upon what the tribunal describes as common law charges. Now, my lords, that passage is important because it's saying that common law misconduct and misconduct based on statutory rules are of the same nature. They are both concerned with professional misconduct, and therefore with conduct that would be regarded, as we'll come on to see over the page, by competent and reputable solicitors as serious and reprehensible. And then the passage continues, there are certain standards of conduct to be expected of competent and reputable solicitors. A departure from these standards, which would be regarded as competent, would be regarded by competent and reputable solicitors as serious and reprehensible, may properly be characterised as professional misconduct. Whether or not the conduct complained of is a breach of rules or some other actings or omissions, the same question falls to be asked and answered. And in every case, it will be essential to consider the whole circumstances and the degree of culpability which ought properly be attached to the individual against whom the complaint is made. And as we've seen, the Divisional Court in Lee Day correctly, I respectfully submit, held at paragraphs 157 to 158 that the same approach should generally apply to the professional conduct rules made by the SRA. May I go back to the question as to why liability under the accounts rules is strict and why that is a clear exception, as the court acknowledged in paragraph 158. We have addressed this in paragraph 23 of our skeleton, and indeed the judge, we respectfully say, correctly summarised the position at paragraph 73 of her judgment. If we could go please to page 99, paragraph 73 of the judgment. Below. The position is summarised in paragraph 73. In Lee Day, the Divisional Court said at 158 that there may be some breaches of some rules, for instance, accounts rules, which can involve strict liability. The accounts rules 2019 are made pursuant to specific rulemaking powers concerning accounts. They are not conduct rules. All of the firms, all of the principals in a firm have joint liability for breaches of the accounts rules in order to provide the public with maximum protection with respect to money held by solicitors in firms. And that has been the position going back a very long time. If we can go please to the supplemental bundle of authorities, tab 3, which is the first edition of the Guide to Professional Conduct and Etiquette of Solicitors, published in 1960. Go please to, I'm afraid the pagination isn't very clear, but if you can make up page 47 in the bottom right hand corner, it's black against black, I'm afraid. Internal pagination 42.
Yes.
You see the position in relation to the accounts rules. I won't read it out, but it's sidelined for you. That it's the responsibility of all principals to ensure that they are complied with.
Yes.
And that position is now reflected in the modern rules. Rule 1.1 of the accounts rules, if the tribunal please could take up volume 5, tab 55 of the authorities. Where you see rule 1.2 on page 1409. The authorised body's managers are jointly and separately responsible for compliance by the authorised body with the accounts rules.
Just give me that reference again.
Page 1409, my lord, tab 55 of the authorities.
Yes.
Now, turning, if I may, to the judge's reasoning on this point, if your lordships would be kind enough to go back, please, to paragraph 73 to 74 of the judgment at page 99.
Just before we leave the subject of accounts rules, why should there be this difference, if you're right, that a solicitor can be strictly liable under accounts rules
Yes.
for something which involved no personal fault at all, nothing else the individual could have done, and you say that's unique among professional obligations.
Yes, in terms of breach. Yes.
Yeah.
Well, it reflects the importance of maintaining confidence in the profession, particularly as regards the sanctity of client money. When your lordship is held responsible, I mean, the degree to which or the way in which the solicitor is held responsible will depend on the circumstances. No fault required for a breach. But if you have, for example, a case of a partner who's let someone else get on with the accounts rules and hasn't personally seen to it or exercised proper oversight, the view of the regulator is likely to be that there is an element of fault there. But it is a special rule, not a conduct rule. Now, a breach of the conduct of the accounts rules may give rise to a breach of a conduct rule. I mean, if it is a serious breach, you may have an allegation that you breached the account rules, you've breached Principle 10, for example, or you've acted without integrity. But they are technical in their nature. I mean, there are quite specific provisions about the circumstances in which money can be withdrawn, how it's withdrawn, how the account is kept, how the account is named, and they are, in the true sense, black letter rules that must be complied with.
If there is a breach of that, and
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the West Green Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
3.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the West Green Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
If you can remember what the question was.
Well, I see the time, but I think the answer, at least I can remember, which is you were asking about the accounts rules and why are they different? They are not conduct rules. They are.
I appreciate that, but say, for example, the SRA decided to allege professional misconduct under one of the principles, but based on the breach of the rules.
Yes.
You would say that in order to through professional, there'd have to be particularly serious breaches, or would that not be part of the matters that had to be proved by the SRA?
Yeah, I would say that the former, they'd have to be serious in the sense serious and reprehensible.
Yeah.
However, the SRA can bring a bare accounts rule
Yes,
breach.
yeah.
Or indeed, anyone can complain to the tribunal. You don't need to be the SRA.
And that wouldn't require.
Well, not in terms of the assessment of whether it's being breached, but no doubt seriousness would be relevant to the SRA's decision as to whether to prosecute and also in relation to sanction. But at the question of breach, no, they are, I accept, in a class of their own and have been regarded as such for at least 86 years, going back to 1960, the guide. Well, I see the time. I don't know if we can safely leave the building or not, but
Well, this probably not allowed to say this, but when these things happen on the stroke of one, it's almost always a fire drill. But it's a fire drill in the West Green building. Anyway, good luck. We'll see you at 2 o'clock.
Thank you,